Namaste students, I'm Dr. Manu Singh from Jyoti Vidyapeeth Women University Jaipur, and in this session I'll be dealing with subject public international law. And under public international law today I'll be dealing with the topic relation between international law and municipal law. So first of all we'll be knowing about the meaning and nature of international law here and what is the relation between the municipal law. So first of all we'll be knowing what is the international law. As I have discussed earlier in my video, international law is a particular law which governs international relations of the international community. International law is that law which regulate international issues, which governs international laws and regulations, and which governs, or we can say, which regulates international community. Whereas municipal law is another word is we can define it is a national law. Is a state law, particular we can say as which regulates the private matter of some nation. So there is a difference between the two areas. The international law which govern the international relation of the international community, whereas municipal law which governs the internal matter of a particular state, of a particular country, of a particular nations. So there are, to understand these two concepts, or to understand the relation between the international law and municipal law, there is several theories which have been discussed by several jurists. So there are four theories through which we will be trying to understand what is the relation between the international law and the municipal law. So one by one we'll be taking and we'll be understanding the concept and these what are these theories. So there are four theories. First of all, I'll just say the name of these theory. The first theory is Dualistic Theory. Second is Monistic Theory. Third is Transformation Theory. And fourth and last is the Delegation Theory. So first of all, we'll be understanding about the Dualistic Theory. What is the Dualistic Theory? So let's see what the Dualistic Theory says about the relation between the municipal law and the international law. So Dualistic Theory emphasizes the difference between national and international law. So this particular theory emphasizes what is the difference between the international law and the national law. So, and require a translation of a later into former. So without this translation, international law does not exist as a law. So international law has to be national law as well as, or it is no law at all. So if a state accepts a treaty but does not adopt its international law in order to conform to the treaty, or does not create a national law explicitly incorporating the treaty, then it violates international law. But one cannot claim that the treaty has a proper or has become a part of the national law. So we will further discuss this particular theory. The Dualistic Theory, according to Dualistic view, system of international law and municipal law as a separate and self-contained to the extent to which rules of one are not expressly or tacitly received into another system. So in the first place, they differ as regard their sources. So now we will be moving towards the second one, that is a monistic theory. So we will try to understand the concept of this monistic theory. So monistic assumes that national and international legal system form a unity. Both national rules and international rules that a state has accepted, for example, by way of treaty, determines whether actions are legal or illegal. In most monist state, a distinction between international law in the form of treaties and other international law, for example, just forgeance, is made. So international law does not need to be translated into a national law. The act of rectifying the international law immediately incorporates into the national law. So this is a dualistic theory concept. Now we will be moving towards the next one theory. There is a transformation theory. So according to this theory, it is a transformation of the treaty into national legislation, which alone validates the extension of individuals of the rules set out in international agreements. The transformation is not merely a formal but a substantial requirement. So international law, according to this theory, cannot find place in the national or in municipal law unless later allows it machinery to be used for that purpose. And next we will discuss about the more concept of this theory. This theory is a fallacious in several respects. The last theory we will be discussing, there's a delegation theory. So according to this theory, there is a delegation of a right to every state to decide for itself when the provision of a treaty or convention are to came into effect, and in what manner they are to be incorporated in the law of the land or municipal law. So there is no need of transformation of a treaty into a national law, but the act is merely extension one single act. The delegation theory is incomplete, for it does not satisfactorily meet main argument of the transformation theory. So it assumes the primary of international law order, but fails to explain the relation existing between the national and international law. So basically these are four theories which I have discussed or elaborated in front of you, student. So basic agenda of these theory is, what is the difference between the municipal law and the international law. Some theories supported this concept. Yeah, there's a difference between vast difference between the municipal law and international law. Some of theories supported that there is no difference between international law and the national law. So as I have discussed earlier in the session, international law is that law which regulates international community, which regulates international treaties. And what is the municipal law? Which is a national law. As a particular country's law is called the municipal law, which regulates their very private issues, or we can say their very local issues. So I hope this session would be useful for you. Thank you.